want to follow up a little bit on the previous questioners now that the door's been opened, so to speak. Ms. Fredrickson, you stated that there is a lot of information out there about the relationships, as you put it, between the Trump administration and Russia. Are you aware of any actual evidence to support an allegation of collusion between the Trump administration and the Trump campaign and Russia?
As I mentioned, it's been well documented that there were over 100 contacts between Russians and various members of the Trump campaign, the Trump family, and up to the Trump administration.
Where has it been documented?
If you've been reading the newspaper or watching television, it's been all over the place.
Publicly available?
Publicly available.
Okay. So given that the special counsel issued more than 2,800 subpoenas, executed nearly 500 search warrants, interviewed approximately 500 witnesses, issued approximately 50 orders authorizing use of pen registers, do you believe that he was, that he had this information as well?
I think it's really important to read how it was phrased by the Attorney General, which is that it was not established. He didn't say there was no evidence. There's clearly some evidence, and I think it's important that Congress examine it, because even if, and one has to actually see the full Mueller report to understand how he evaluated the evidence, but even if there wasn't enough to show beyond a reasonable doubt, and one assumes that's the standard that he was using, although perhaps not the appropriate standard for an indictment, one has to ask, was there enough for Congress to find highly problematic relationships between the variety of players representing either officially or in some private capacity the Russian government with the Trump campaign, with the Trump administration? I think those are all very important questions for Congress to examine.
So, with regard to conspiracy, the issue of whether or not there was obstruction of justice, the question is, does the department have the authority to determine whether the evidence rises to the level of a chargeable offense?
Well, it's very interesting because I think, as Attorney General Holder has stated, in his 6 years in running the Justice Department, he never had one of his prosecutors present him with a case and not come to a conclusion. I think one has to look historically at the other times when there has been an obstruction of justice inquiry into presidential behavior, and in those particular circumstances, that has been presented to Congress to resolve. And I think one can intuit that that's perhaps what Mr. Mueller was thinking, and that nonetheless the Attorney General put himself in the place of Congress and made that decision.
So it does not, that power does not reside with the Department of Justice to determine whether an offense?
I didn't say that, but traditionally it's been with the prosecutor who's been leading the investigation to recommend a decision, and in this case, Mr. Mueller didn't. Again, consistent with past obstruction of justice inquiries into presidential behavior, and certainly quite unprecedented for the Attorney General to substitute himself in this way.
Unprecedented for the Attorney General to determine that there's not enough evidence to proceed with the charging of an obstruction of justice charge.
As the Attorney General Holder said, he'd never experienced such a situation in his 6 years running the Justice Department when there was no recommendation from a prosecutor to conclude an investigation. And Mr. Mueller said very directly, and that was actually quoted by the Attorney General, that the President was not exonerated.
All right, thank you.